Hello, and welcome to On Subrogation. In this video, we're going to answer a question that one of our viewers specifically asked about MedPay and PIP subrogation. If you have a topic you'd like to see discussed in our videos, please email us at video@rathbonegroup.com. I'm Jason Sullivan from Rathbone Group, and Scott emailed us this question after viewing our MedPay and PIP videos. His question was, what do you do when another carrier claims that there's no subrogation right because your insured has not presented a bodily injury claim? First, that's a great question, and it is something that we see that comes up from time to time. The common scenario is your insured is injured in an accident, you pay out MedPay or PIP coverage to them. Then you send your subrogation demand to the other carrier, and you get a denial. That denial is not based on liability or causation or anything about their own policy. Rather, it simply states that your insured has not presented a bodily injury claim, and therefore you have no right of subrogation. So, what do you do when you get this information? The first thing I like to think about is, what's the economic reason or incentive for a carrier to make this denial? It's more than just them not wanting to pay the claim. An adjuster on the liability side has an obligation and duty to mitigate or reduce risk. If there's a party that's been injured and you've paid MedPay and PIP, yet that party hasn't raised a bodily injury claim, there's a big unknown in the amount of risk that's presented to that insurance carrier. So logically, if they can push off a decision until they know whether or not a party is going to present a claim, that's in their benefit. It's not in your benefit as the subrogation carrier, but understanding that incentive helps make a plan of action on how to approach it. So let's look at three scenarios in three different states. First one being Ohio. In Ohio, a MedPay subrogation claim, there's a direct right for the carrier to pursue the adverse party. It does not matter whether or not your insured presents a claim, you have that right of subrogation for that benefit you've paid. If you get a denial on the basis that there's no bodily injury claim being asserted by your insured, first thing I do is reach out to the insured. It's a great way to have a good customer service touch point with your insured to find out, are they still treating, do they have additional damages or pain or suffering, or things that aren't necessarily covered under your policy. If you find out the answer is yes, then you know that very shortly this artificial obstacle that there's no BI claim, that's going to disappear when your insured makes the claim. If you're unable to get that information, or you do find out that your insured's just not interested in presenting a claim to the other party, then you have some options. You do have the right to pursue those independently of whether your insured does or not, and you can make the decision on how to proceed up to and including litigation. Let's take a second example in the state of Washington where PIP subrogation is most common. In those cases, if your insured does not have a bodily injury claim, then it becomes a question of whether or not the made whole doctrine is going to apply. So in this case, let's say the other carrier is a member of intercompany arbitration, and so you file your contention for your PIP subrogation claim. The other carrier denies the claim on the basis that the insured's not been made whole, and the arbitration panel says, yes, we agree, and so they draw it or kick it out of arbitration. So what do you do? Again, first thing to do is reach out to the insured and find out, do they have a claim and are they made whole? If you can get the insured to sign a piece of paper that says they've been made whole, that would be very strong evidence that could be supported in favor of your claim that the insured's been made whole and you're allowed to proceed with your subrogation claim. If you can't get that information as to whether or not they've been made whole, or you don't know if they're going to proceed, you can wait until the statute of limitations gets closer and refile the ARB, arguing again that once the statute expired, if no claim was brought up, that's presumptive evidence that the insured was made whole. Taking a look at a third state, in California, where MedPay is, there's no direct cause of action against the tortfeasor for MedPay subrogation claims in California. In that state, if a carrier were to say to you, your insured hasn't presented a bodily injury claim, and therefore there's no right of subrogation, that's probably going to be an accurate statement of law in California, and you would have no right of subrogation against the other party. You would still have your right of reimbursement, provided that's in your policy language with your insured, and your insured pursues a claim. If they don't, no BI claim probably means no subrogation recovery for your MedPay. Hopefully this answers your question, Scott. If you have any topics you'd like to see or a question you'd like to have answered here, please email us at video@rathbonegroup.com. For Rathbone Group, I'm Jason Sullivan, and that's the long and short of it.